The broadcast is now starting. All attendees are in listen-only mode.
Hi, everybody. This is Charles C. Ballmeyer with NetLaw, and thank you for joining our workshop today. I want to give it just another couple of minutes to allow others to join us. So please be patient, and we'll get started here shortly. Thank you. All right, everybody, let's go on ahead and get started. I want to hand the announcements off to Tharu. So, Tharu, if you want to go on ahead and say a few words, that would be fine.
Sure, ma'am. Hey, good morning to all the participants and ATA family. And I want to give first a special thanks to Shankar Reddy Bandi, who is my mentor and the main root cause to connect me to ATA and initiated this whole webinar by talking to Anil Reddy, Karnakar Reddy, Parmeshwar Reddy Garu, and Ramakrishna Reddy Garu. So thanks for all the ATA team and thanks to Dallas ATA team, Ajay Reddy Garu and the team. So I would like to introduce Miss Chelsea Balmer, who is she's an attorney and having more than 20 years of experience. And she's also vice president of NetLaw. And so initially the NetLaw, I joined with the NetLaw and helping the families for a couple of maybe more than a year or so. And the service they provided and the response from Ms. Chelsea for any question or any concerns is the best. And their team also very attentive and very prompt in responding. And that tells the Ms. Chelsea's, sincerity and professionalism there. And so she helped so many, I think thousands and thousands of families and educating this, will and trust. And also, she also supports the non-profit organizations and bunch of non-profit organizations. And also, she's a great mentor for youth, like how to, plan their life and all those things, the counseling stuff. And I heard, I had so much great about Ms. Chelsea's, and I'm just able to explain only few of them. The top, even though she has a great credentials. And my personal and behalf of ATA family, I would like to say very big thanks to Ms. Chelsea's for her availability and also providing all the information needed for this Will and Trust webinar. And thank you, Ms. Chelsea, once again. And I would, please go ahead from now. And yeah. Thank you so much.
Thank you, Thuru. I appreciate you pulling this together and gathering such a nice group of people to listen to me speak today. Looks like we've got a great attendance, so I appreciate you all giving me some time on your Sunday. I know there's other ways that you would probably much rather spend your time than listen to an estate planning seminar, but I hope you get a lot out of the session here today. So what we're going to do, and I've got everyone is muted. I will leave everyone muted while I am presenting. If you think of questions as I am presenting, please just write them down. And once I get through the presentation, you can raise your hand. So if you're looking in the control panel of GoToWebinar, there's a little section where you can raise your hand and I will unmute you so that you can ask a question. Or if you prefer, you can type those questions into the questions box that's also located in the GoToWebinar control panel. Sometimes that's a little bit easier for me to read the questions. Sometimes it's a little difficult to hear, but either way, we'll get through this together and I'll get all of your questions answered. So let's go on ahead and get started. I want to first off tell you guys a little bit about the company. NetLaw is a technology company. NetLaw is not a law firm. However, the company was created by the law firm of Hargrove Madden, which is now known as Hargrove Trauber. The law firm went through a name change recently, but we created this system in our private practice. As a law firm, we were looking for a better way to serve our clients, a more efficient manner to deliver our services to those clients, and to really have a very secure and encrypted environment that we could communicate and collaborate with the client and their other professional advisors. We're very inclusive and collaborative as a practice, and we feel that it's in the best interest of the client to have all of their professional advisors kind of working together to coordinate a plan that really makes sense for each family. So when we created this software, it was designed originally to be a tool in our practice so that we could draft documents. So it's a very sophisticated drafting tool, as well as a mechanism to store information for the client in a very secure and encrypted manner. So we launched an online estate planning platform with our law firm. In 2012, the American Bar Association recognized our law firm for this technology, for this system, and awarded us their James Keene Award for Excellence in E-Lawyering. And that's an award that they give to one law firm in the country. So out of all of the law firms in the entire US in 2012, we were lucky enough to receive that award. And that's really what got us to thinking about how can we make this better? How can we put these tools in the hands of more people? Statistically, 70% of adults in this country do not have a simple will. 70%, and that's just an unbelievable statistic. When you look at everything that's included in a comprehensive plan, all of the documents included in the NetLaw plan, 90% of Americans don't have all of the documents included in this estate plan, which is vitally important to everyone. And we're going to talk about why that is today. So I mentioned that to you because I'm willing to bet that those statistics probably ring pretty true for those of you all on the call today. You're lucky that you're not standing in front of me in a live meeting because I may ask you to raise your hand if you fall into that category, but I'm just joking. I wouldn't put you on the spot like that. But it's really something that is very astonishing, and that's true for everyone. You know, that's not 70% of just average Americans. That's 70% of all Americans, including the extremely wealthy. In the 20 years that I've been doing this, it never ceases to amaze me the multi-millionaires that I meet that don't even have a simple will. So if you don't have one either, don't feel too bad. You've got a lot of company, but we're going to take care of that, right? So this is our premium estate planning package. This includes what I call the foundation of every estate plan. These are the building blocks of every single estate plan, regardless of whether you're Bill Gates or you're Charles C. Ballmeyer. Every estate plan starts with these documents, and then you build on that based on the complexity of your particular situation. So included here is your last will and testament, a probate avoidance revocable living trust, financial power of attorney, medical power of attorney, living will, also known in some states as an advance directive, your HIPAA authorization, and the life vault. The life vault is that secure encrypted environment that I mentioned. And the way we utilize that with our clients is that is a place where you can store all of your estate planning documents once they're properly signed, witnessed, and notarized. You can scan copies of those into your vault where you can have access 24 hours a day, anywhere with internet access. So if you're traveling and you get in an accident and you need your healthcare documents, you can access them right from your mobile device and get them straight over to the hospital in a very secure manner. But you could also use this vault to store anything that is important. So if something were to happen to you, your family can find your life insurance policies, your account statements, the deed to your home, birth certificates, passports, anything really can be stored in this life vault. And this is a great place to kind of organize the important documents of your life. In the past few months, this country has experienced some significant national disasters with the hurricanes, with the fires. When you experience something like that, what are you thinking about typically? You're thinking about your possessions, right? Your home, your furniture, your family photos, things like of that nature, clothing, things like that that you're going to have to replace. But what do most people not think about? They're important documents. And how do you go about reconstructing the documentation of your life? Where do you even begin? Are you even going to remember where you have all of your life insurance policies placed, what companies you have those placed with? So it would be really helpful if you had all of that stuff stored electronically in your vault. Kind of takes a little bit of the pressure and the burden off of trying to reconstruct that. That's what a lot of our clients are doing, is just making sure that they've got that in one safe place. This is also a place where you can store, like I said, anything else that is maybe just has sentimental value. In my particular vault, I have a folder that's set up and it has my mom's name on it. It's a folder within my vault that has her name on it. She passed away about going on 10 years ago. And after she died, I, kind of pulled together, I found some cards that she had sent me and some letters that were written in her own handwriting. And that is just so precious to me. Most people don't correspond by, handwritten correspondence anymore. So I scanned those items and put them in my vault so that if there was ever a disaster, they got lost or in a fire or a flood or what have you, at least I have them saved electronically. So I encourage you to do the same. I want to also point out that part of being a NetLaw client gives you access to our national network of estate planning attorneys. These lawyers are vetted for their experience and expertise in estate planning. This is what they do. This is their specialty. So these attorneys are not general practitioners. They are not brand new law school graduates. They have significant years of experience and expertise solely in this area. So think about if you had a health problem. If you broke your leg, what kind of doctor would you go to? Probably an orthopedic doctor, right? Well, if you've got an estate planning need, don't you want to go see a specialist in that area? Don't you want to work with a company that specializes in that area? Of course you do. So that's kind of the same concept and the same reason why these lawyers have to devote a significant amount of their practice to estate planning. Now, that being said, I want to remind you that you can create all of these documents entirely on your own without the help or assistance of an estate planning attorney. So why are they there? We have those attorneys available for those that have more advanced needs, or for individuals that just want to talk to an attorney. They just want to make sure that they did everything right. They have the ability then to connect with one of the attorneys. I do want to point out, however, that these lawyers are independent from NetLaw. They're independent practitioners. So if you engage them for time and or services, you will need to be prepared to pay for that time and services. The rates depend on each individual attorney. It varies from attorney to attorney. It varies depending on what part of the country you're in. You know, here in Louisville, rates might be anywhere from $200 an hour to $700 an hour. In New York, they're probably significantly higher. So, but you have the ability to view the profile of these attorneys, see what their rates are, see if they give a free consultation. Some of them do. And then you decide who you want to engage for additional services if you need them. Now, what is included in the plan at no additional cost are documents for your spouse. So if you are married, your spouse can create these same sets of documents at no additional cost. So one NetLaw plan will cover documents for both spouses. So that is just an unbelievable opportunity for you. I can tell you in our private practice here in Louisville, Kentucky, for a husband and wife to come see us for this same set of documents, and mind you, we will use the same software to create them because we still use this software in our private practice to draft documents for our clients, but we would charge you $3,500 for this package of documents. You know, through Theroux, because of our relationship with him and HGI, you guys have the ability to create these documents in this package for $600. And, you know, that's an amazing value for you. So, you know, really take advantage of that. So let's talk a little bit more about estate planning and what some of the key issues are, what's important to know, what's important to consider. And, you know, a lot of the things that I hear from clients, a lot of the big issues and concerns kind of boil down to these three things. And this is really kind of a universal truth. We all want to maintain control. So let me ask those of you on the call here, maybe some of you have adult children. Are you ready just to turn over all of your assets to your adult children right now because you're confident that they'll take care of you, that they'll pay for everything for you, and they'll care for you in the manner that you want to be cared for? Well, maybe you're in the minority, but typically no. We all want to maintain control, right? Control of our assets, control of distribution of those assets, investment of those assets, control of your health care, all of that. So without that control, do you really feel financially secure? Probably not. You know, so part of planning is making sure that the control stays in your hands so that you can have that security. And then also having the ability to manage and preserve those assets, not only for yourself during your lifetime, but also for future generations. You know, I always like to point out that estate planning is not just about death and dying. It's not. It's about protecting yourself while you're still living. And with proper planning, you can do that. So let's talk a bit about probate. Maybe you've heard a little bit about that. It is, in many respects, a very burdensome process. There are about a half a dozen states in the U.S. where it is extremely burdensome, extremely costly. Some of those states would include California, Texas, Florida, New York, Louisiana, a couple of others. And the reason for that is, you know, in those states, the creditor's claim period is extensive. The attorney's cost in some of those states are based on a statutory percentage of the estate. So regardless of how much or how little work the attorney actually does for the estate during that probate process, they have the right by statute to charge a certain amount of money, regardless of how much work they do. That's just part of the state law. So, you know, so let's talk a bit more about that. Let's talk a bit more about just the whole process in general. So probate is burdensome for the family for many reasons. Number one is because when you pass away, the court is going to freeze your assets. Your family will not be able to access those assets for a period of time. The reason the court does that is because they publish notice of your death in the newspaper where you live, typically more than once, to give notice to creditors that are out there. It's called the creditor's claim period. Creditor's claim period. And that varies from state to state, but on average across the country, it's about 6 months. You know, some states are a little less, some are even more. You know, some states are 12 months, some states are 3 months. Most states, however, on average are, 6 months. So during that 6-month period of time, your family can't access those assets. because the court has to preserve them in case a creditor comes forward and makes a claim. Now, that creditor's claim period begins on the day that probate is initiated, not on the day of death. So oftentimes there's a bit of time in between someone passing away and the time that the family initiates probate, right? There's a grieving process. You have to get through the funeral, all kinds of things like that. You know, maybe you're not even sure what probate is or if you even have to go through it. So by the time you get around to it, maybe a month or 2 or 3 has passed, and then you start that creditor's claim period. So think about that. If your family had to make do without the assets that you own for a 6-month period, 9-month period of time, that can put a significant financial burden on the family, right? You add to that the attorney's costs, the court costs, and very quickly it becomes a big burden for the family. So how do you avoid that process? How do you avoid having to go through that? We're going to talk about that. But I do want to point out that what triggers the probate process are individually owned assets. Anything that has a title and that title just has your name on it is a probate asset. So a bank account, a car, a piece of real estate, an investment account, anything that just has your name on it is probate property and will have to go through that probate process. That is true whether or not you pass away with a will, which is known as dying testate, or if you pass away without a will, which is known as dying intestate. Those assets will have to go through that probate process before they can get to your family. Now, the difference is if you pass away with a will, you decide who gets those assets. You can determine where those assets are distributed. If you pass away without a will, your state will decide. It's intestate succession provisions. Every state has that. Every state has a law that says who gets your assets if you pass away without a will. Don't take for granted that your spouse is going to get everything just because you're married. That may or may not be the case. For example, here in Kentucky, where I live, if I passed away without a will, my husband would only be entitled to half of my assets. He would not be entitled to all of my assets. So please make sure that you're aware of what the laws are in your state and that you're being proactive to make sure that those that you intend to benefit from what you've spent your lifetime building actually benefit. So it's very easy to do. I do want to point out that there are assets that pass outside of the probate process. Those are considered non-probate assets. That would include anything with a beneficiary designation, such as life insurance or retirement accounts. Those are going to pass according to those designations, regardless of whether or not you have a will, regardless of whether or not you have a trust. So consider maybe you're in a second marriage. And have you thought about reviewing your beneficiary designations? Do you still have your ex-husband or your ex-spouse, your ex-wife on those accounts named as the beneficiary? Just because you got remarried doesn't change that. You have to go in and change those beneficiary designations to name your new spouse or whomever you now want to benefit from those assets, because the beneficiary designation will prevail. Also, anything owned by joint with rights of survivorship. So a lot of times married couples, for example, will own assets, particularly their home, jointly with rights of survivorship. So my house is owned jointly with my husband. So it's the Blake and Charles C. Ballmeyer joint with right of survivorship. So whichever one of us passes away first, probably my husband, because they always die first, whether they want to or not in some cases. When my husband dies first, the house will pass automatically to me as the surviving owner. It'll go outside of probate. But then what happens? So we've effectively avoided probate at the first death, right? Because we didn't have to go through probate with that property when my husband died. But now that he's gone and it passed to me, it's now considered individually owned by me. So when I die, my family still has to go through probate before the house can be distributed or sold. So in many respects, it's much easier to do that ahead of time. So let's say that we didn't do that. Let's say that we didn't transfer our home into the revocable trust right now, because we know we're going to avoid it at the first death, right? So I'm 44. let's say that my husband lives another 30 years. That would make me 74 when he dies. Okay, now I'm 74. Am I going to really know what to do or who to contact or who to talk to, and how much is it going to cost me in 30 years to transfer the property into a trust at that time? Am I going to be, mentally competent at that time? What if I've developed dementia? So, in my opinion, it's much better to be proactive and take these steps now while you're young and healthy and mentally competent and capable and able to understand and get these things done now rather than waiting until your later years. So that's just something to think about. So also, anything that is owned by a properly drafted trust, such as the NetLaw Revocable Living Trust, anything that is owned by that trust will avoid probate. So that's one of the key tools within this plan today, and we're going to talk a bit more about how you can use that to accomplish that goal. I do want to point out, however, that if you are able through various means to avoid going through the probate process, that does not necessarily mean that you are going to be able to avoid paying estate tax. Your probate estate and your taxable estate are not necessarily the same thing. So again, what is your probate estate? Probate estate includes anything that's individually owned by you. What is your taxable estate? And I'm referring here to the federal estate tax. Your taxable estate includes everything, including those non-probate assets, including life insurance, retirement accounts, jointly owned assets, and anything owned by a revocable trust is part of your taxable estate for federal estate tax purposes. Now, that doesn't necessarily mean that you will pay taxes. It's going to depend on what the exemption amounts are at the time that you pass away and what your overall taxable estate is worth at that time. So right now in 2017, the federal estate tax exemption is $5.49 million per person. Again, that's $5.49 million per person. And that exemption is portable between husband and wife. What do I mean by that? What is portability? So I will use myself as an example. Let's say that I pass away today in 2017 with $3 million in my taxable estate. So I could effectively use $3 million of my $5.49 million exemption, and the remaining $2.49 million could pass to my husband, so that upon his death, he has his full exemption plus my remaining exemption. So a married couple in 2017 can exempt almost $11 million from federal estate tax. So as you can see, the federal estate tax really does not affect that many people in this country. It's basically 1/2 of 1%. So I do want to point out, however, that if you are not a U.S. citizen, the federal exemption for non-U.S. citizens is only $60,000. That's right, $60,000. And that's true even if you're married to a U.S. citizen. Your spouse has that $5.49 million exemption. You as a non-U.S. citizen only have a $60,000 exemption, and that portability will not apply to that situation. So I encourage you, if you're not a U.S. citizen, to take a look at that, take a look at your overall asset values, and because more than likely, if you're not a U.S. citizen, you need to probably engage one of our network attorneys to have some tax planning added to your estate plan. So let's talk about why it's important to execute a will. I mentioned it briefly a moment ago. Just number one, having the ability to direct how your assets are distributed according to your wishes and not according to state law. However, probably most importantly in my mind is because this is the document that is legally recognized by the courts where you name a guardian for your minor children. If any of you on this call have children under the age of 18, and you do not have a will that names a guardian for that minor child, you are placing that decision in the hands of a judge. A judge that doesn't know you, a judge that doesn't know your family, certainly doesn't know your child, doesn't know your wishes, and you could potentially have a fight on your hands. Maybe one side of the family fighting the other side of the family over custody of that child. Sometimes they're fighting over the inheritance that comes with that child, right? And not necessarily the child. In some cases, I've seen children placed in foster care temporarily until guardianship can be worked out. I don't think any of us want to think about our children being put into the system, which that's what it is. The guardianship is a government-run system until that can be worked out. It can be very traumatizing. So again, those of you with small children, or maybe you have small grandchildren, if that's the case, please talk to your kids and make sure they're taking care of this for those grandchildren. Also, this is a document where you appoint somebody as your executor or personal representative. And this is someone that's going to play a vital role. This is the individual that's going to be identifying your assets, the person that's going to be identifying the beneficiaries, notifying beneficiaries. This is going to be the individual that files your final income tax return. Believe it or not, the IRS does not give you that year off just because you died. I know that's surprising, but they want that last income tax return. And you can bet they want those taxes. If you owe any taxes for that partial year of your life, they still want it. It's not a parting gift when you leave this world. They don't let you just keep that money. So that's a pretty important role. And so make sure you're the one naming somebody in that position and not the courts, because that's what happens when you don't do that. So let's talk a bit more about the revocable trust. I mentioned a moment ago about, how it's a great tool to utilize to avoid probate. But before I expand on that, I want to talk a bit more about how this is a good tool to help you while you're living. You might recall that I mentioned that estate planning is not just about death and dying. I've had clients tell me before, Charles, see, I don't really care. I'm going to be dead and gone. My family can figure it out. Okay, that's fine if you die. But what if you don't die? What if you have a stroke and you're incapacitated? What if you develop dementia or some other condition that renders you incapable of making decisions and managing your own affairs? You're still alive. So do you care then if something, who takes care of you, who makes those decisions? Do you care then how you're cared for? Of course you do. We all do. That's vitally important. So consider that. What if you were to have a stroke and you were unable to manage your affairs? What would happen if you didn't have these documents in place? Somebody would have to be appointed by a judge to be guardian for you, to handle your finances, to handle your medical decisions, to pay your bills, to make decisions on, whether or not to put you in assisted living, to all kinds of things that affect the manner and standard of your care. So do you want to pick out that person, or do you want a judge to pick out that person? What if the judge names somebody that you absolutely would never want handling those things for you? Guess what? You can't do anything about it now, right? Because you can't speak or communicate. You can't handle these things. So by having this revocable trust in place, now I want to point out that this is your trust. You own it. You control it. It maintains your Social Security number, so it doesn't affect your income tax filings whatsoever. You can put assets into it at any time. You can take assets out of it at any time. You can manage those assets. You can change the terms of the trust. You can change the beneficiaries of the trust. You can completely terminate the trust. It is completely at your control. One of those key issues, control. So when you set up this trust, you are your own trustee during your lifetime and until your death or disability. So you set up the terms of the trust. So you set this trust up, you move your assets into it. Maybe you do, maybe you don't right away. And then you have that health event. You have a stroke. You've already got your successor trustee named in the document, right? Because when you set up this trust, you're going to name a successor trustee to step into your shoes to manage your affairs if something happens to you. And that trustee will have to manage those affairs for your benefit according to the terms that you set up when you establish this trust, eliminating the need for somebody to have to be appointed by a judge. That sounds pretty good. I kind of like that option a little bit better, don't you? I would think so. So this is a key tool. This is basically, think of this as a disability planning tool for yourself to make sure that you're cared for if something happens to you. In addition to that, again, this gives you the ability to avoid that probate process. Now, I mentioned that probate is a public process. And what do I mean by that? It's not just that the courts publish notice of your death in the newspaper. That's one aspect. The other aspect is that anybody can go to the courthouse and pull a copy of your estate file, your probate file, see everything that you own, what it's valued at, who your beneficiaries are, even who your creditors are. It's public record. However, if you have a trust and you have your assets owned by that trust before you pass away, this trust isn't subject to court jurisdiction. It's not part of the public record. Nobody even knows about this trust. They don't know what's in it. They don't know who the beneficiaries are. That is all private. And that is a big, big, big benefit. So let's talk about just management of those assets for future generations. Any of you on the call here have son-in-laws or daughter-in-laws? Probably, right? Maybe some of you have son-in-laws or daughter-in-laws. Well, think about this. Would you want your son-in-law or daughter-in-law to potentially walk away with half of your child's inheritance one day? Would that be okay with you? Probably not. Now, my daughter's 11 years old, and I can already tell you that I never, ever want any future ex-son-in-law of mine to get a penny of her inheritance. Call me crazy, but I want that money to stay in my family. I want it to benefit my bloodline, my children, my grandchildren, my great-grandchildren. And you can do that with proper planning. You can also set out ages at which your child can get access to lump sums of assets. Maybe you want to stretch it out so that they can't get their hands on any big outright distributions until they get a little bit older. So again, this gives you that flexibility. Today, my daughter is 11. I might say today that when she turns 21, she can just have her entire inheritance, just outright in one big lump sum because she's a great kid and, has never given me any problems whatsoever. But she's 11. What happens in the next 10 years? Well, who knows, right? What if she marries somebody I can't stand? What if she develops a drug problem? Well, I can go in and change the terms of this trust at any time to make it such that she has to be 35 before she gets any outright distributions or whatever your wishes are. It's in my ability to do that. It's my sole ability and control to be able to do that. And I like having that flexibility. It's a great, great tool for you. I do want to point out real quickly before we move on that this particular type of trust, because you maintain control of it, remember it's your trust, you control it, you manage it, you're the trustee, et cetera, et cetera. Because you maintain that level of control, this does not give you any kind of asset protection. It gives you no kind of tax advantage during your lifetime. So what do I mean by that? Let's say that you get into a lot of debt and you want to file for bankruptcy, but you don't want to lose your assets. Well, if they're in this type of trust, they're still going to be subject to that bankruptcy. And why is that? Because the judge is going to tell you, hey, you put those assets in, it's a revocable trust, you can take them out, so go take them out and go pay your bills. That's how that works, right? This is also not going to protect those assets from any kind of Medicaid spin down. So for clients that are, thinking of the future and they're thinking that they may want to try to qualify for Medicaid in the future, this is not going to protect those assets from that Medicaid spin down. I'm not going to go into a lot of detail on Medicaid, but in a nutshell, that is a government benefit for the indigent, which means that you can only have about $2,000, maybe $2,500 of assets in your name to qualify for Medicaid. There is a 5-year look back. So you can't give away all of your assets today and the next week go qualify for Medicaid because they'll look at that paper trail. And if there's been any transfers or any sales of assets for less than fair market value, that's going to disqualify you for that benefit. So in that regard, what I typically like to talk to clients about is instead of being worried and spending a lot of time and effort to try to qualify for, the government to take care of you, how about looking into long-term care insurance? I would much rather spend the money on a really nice long-term care insurance policy so that I know the standard of care and the level of care that I'm going to receive, and instead of trying to waste a bunch of time and effort to spend down my money so that I can qualify for the government to take care of me. One of the jokes that I always say is, and I always use my sister Tina, my older sister, as an example. She's 58. And recently just talked her into long-term care insurance, because this is, and it took it to this point. We had this conversation time and time again, but it wasn't until I made this comment to her that she was like, "You're right, Charles, absolutely." So think about it, guys and girls, especially ladies on this call. So, ladies, we live longer, right? We're going to outlive our husbands. Typically, women are 3 times more likely to be widowed than men, right? So you couple that with the fact that we make less money than men do, we have less in savings for retirement than men do, and we've got to live longer, right? So how do you make that happen? What if you have to go into assisted living, right? So long-term care insurance. And what I told my sister was, when she was talking about Medicaid taking care of her, I said, okay, Tina, you go and you stay in a Medicaid facility in a Medicaid bed somewhere. I'm going to take my long-term care insurance and I'm going to be in the penthouse of the best nursing home in Kentucky. And since there's only going to be a handful of eligible men in that nursing home, because, men die first, they're all going to want to date me because I'm going to be living in the penthouse. So again, it's just a standard of care. Do you want to be in a Medicaid bed, or do you want to be in the penthouse of the nursing home? So I know I took a little side road there, but I just wanted to illustrate, the fact that, this planning is really more than just the right here and now. It's really an investment in your future, guys. So let's talk a bit more about the other documents. The financial power of attorney. That is another key document to protect you while you're living. It works hand in hand with that revocable living trust. Excuse me, sorry about that. So for example, let's look at that same situation where you've had a stroke. So you've had a stroke, you've got this financial power of attorney in place, you've got your NetLaw revocable living trust in place, and maybe you've got some assets already in that trust. Maybe you haven't moved them all into that trust yet. So what can happen now? The person named in your financial power of attorney, who might be the same person you've got named as your successor trustee, maybe not, it doesn't have to be, but the person with their power of attorney for you can take any assets that you have not already moved into your trust, move those assets into your trust for you. Then the successor trustee that you named can then manage those assets for your benefit. It's just a really great tool, but it's also, something that can assist you in other events, not just in an event of an incapacity. Let's say you're just out of town and you're selling your car and you need somebody to sign the deed or write a check to pay a bill or maybe vote stock on your behalf. Those are the kind of things that this financial power of attorney can help you with. The other documents, your medical power of attorney, that one's so important. I always get questions about, at what age should somebody start thinking about this kind of planning? Well, let me ask you, are you 18 years of age or older? Then you need to be thinking about this. What happens when you turn 18? Anybody on the call today have teenagers? Maybe a child that's getting ready to turn 18, maybe a child that just turned 18, maybe a child that's in college. Let me ask you, Mom and Dad, did you have that child sign a power of attorney, the financial power of attorney, medical power of attorney, advance directive, and HIPAA authorization, naming Mom and Dad, so that if something happens to that child, you can now help them. You can manage their finances. You can make their medical decisions. You can speak freely with their physicians. If you did not do that, and something happens to your child, you're going to have to petition the court to be named as guardian for your very own child, because they're now legal adults and your rights as a parent have been severely diminished. You no longer automatically have those rights. If your child's in college, you can't even call the school to see if they're attending classes without that documentation. So think about that. That's pretty scary, right? So the medical power of attorney is the document where you name someone to make your medical decisions if you cannot do so for yourself. So if you're, in an accident and you can't speak or communicate for yourself, who do you want making those decisions? If you don't put that in writing in a legal document, guess who's going to name somebody? It's going to be a judge that's going to name someone to handle your medical decisions for you. Now, again, you probably know who you would want to do that. And you probably know who you would never want making your decisions, right? But a judge doesn't know that. A judge doesn't know who you would and who you would absolutely never want making those decisions. So how do you let them know? You do that by creating these documents. The living will, also known as an advance directive, is the document that you utilize to declare your wishes with regard to life support, artificial nutrition, hydration, and respiration. So if you wish to be allowed to die naturally without those artificial interventions, you need to let people know by creating this document. If you wish to be allowed to remain on those artificial interventions indefinitely until your family runs out of money or what have you, that's okay too. It's a personal decision, but it is a decision that you need to declare in a legal document. So guys, I ask you, what is your legacy? How do you want to be remembered? How do you want to be cared for? How do you want your family to be cared for? Those are some pretty important questions, right? So while you're pondering that, I'm going to hop off here of the PowerPoint and I'm going to go into a NetLaw account because I want to show you how easy it is to create these documents, how to access all of these tools, because a lot of times people don't believe me when I tell them how easy this is, but you're going to see here firsthand. So once you get set up with your account and you set up your username and password, it's going to take you in to the account to this screen and you're just going to click here where it says Get Started. And we're going to take you through a process of answering and filling in some information about yourself and your family and your kids and that kind of thing. Please go through this getting started process first. I know it's super tempting to want to go over here to the left-hand side and click on legal documents and get started right away, right? But don't do that because you're going to need to go through this and enter in information because that will assist you in going through the legal document section as we go along, and you'll see why here in just a moment. So I'm just going to go on ahead here and enter in a fictional client. We'll say that his first name is John, last name is Smith. We'll say that John's middle initial is L. Smith. And this section right here where it says full legal name, however you want your name to appear in your documents is how you need to type it in this field. So if you want your middle initial, great. If you want a period after your middle initial, awesome. Just put it in there. So whatever you type here is exactly how that's going to show up in your documents. Let's pick your gender. Make sure you get that correct. Please also make sure that you enter in your exact birth dates. That's very important as well. You'll see why as we go along. Birthday, phone number, click next. It's going to ask where the client is located. Where do you live? And this is important because this is what dictates the jurisdiction for which your documents are created. I want to point out that NetLaw is not a fill-in-the-blank form system. NetLaw is a very sophisticated drafting tool. So what you're doing when you're going through this process is you're using the same drafting tool that we use in our private practice. You're using the same drafting tool that our attorneys in the network use to create documents in their private practice. So it's very state specific. It's very state compliant. Every single document is custom drafted for you based on the information that you enter into the system. So I'm going to click next, and then it's going to ask about my family. It'll ask if I am married, if I have children. So let's say that yes, that this client is married, that yes, this client has children. You'll see here that it's asking if you have a pet. The reason it's asking you that is because it's going to give you the ability to set up a pet trust if you want to. That is included in your plan at no additional cost. That's right, I said pet trust. That may sound a bit funny, but it's actually very heavily utilized. A lot of clients, especially here in Kentucky with the horse industry, if you've got an animal that lives a really long life, like a horse or some birds, it's very common to see clients set up pet trust for those animals, to care for those animals once they pass on. I'm going to say no. I do have a couple of kitty cats, but I'm not going to leave them any of my money. Some of you might remember Imelda, was it Imelda Marcos? She left, I think, $12 million in a trust for her dogs. So here it's asking for information about the client's spouse. So we'll say that her name is Jane Smith, and we'll say she's Jane R. Smith. And again, exactly how your spouse wants their name to show up in the documents is exactly how you need to type it in that field. We'll add in birthday. And now it's asking here, does your spouse have the same address as you do? Now, again, I know that may sound a bit funny, and maybe some of you are thinking that having two separate addresses sounds like the perfect marriage. I don't know. But the reason we ask that is because it's actually quite common here in Kentucky in particular, especially in our private practice. We see a lot of times husband and wives, one spouse might be a legal resident of Kentucky, where the other spouse might be a legal resident of the state of Florida for income tax purposes. There's no state income tax in Florida, so we see that quite a bit. With one NetLaw account, you could create documents specific to Kentucky law for the Kentucky resident and another set of documents specific to Florida law for the Florida resident, all with one account, all at no additional cost. So that's why we ask that question. Here, I'm just going to say no for demonstration purposes. Also, guys, I want to remind you, I think I mentioned this as we started, I just want to make another reminder. What you're looking at and what we're talking about today is purely for education and demonstration purposes only. Again, NetLaw is not a law firm, so we cannot give you legal advice. I can't give you legal advice. This is, again, just for information and demonstration purposes only. So now it's asking to enter information about your children. To do that, you click on where it says here, add. So I'm going to click on that. I'm going to add in a child, and we'll say that this client just has one child. We'll put in the birthday. Please be very precise about the birthdays. It's very important. And then here is where I identify the relationship of that child. So is this child John's child of a current marriage, his current marriage to Jane, or is this a child of a prior relationship, or is this his stepchild? So let's just say that it's the child of this current marriage. And I'm just going to name the one child. Obviously, if you have more children, you could just keep on clicking add to add more children. But for time purposes here, I'm just going to add one and then click next to continue. Now, those of you who have been invited by Theroux or maybe another advisor, this will be pre-populated for you with Theroux's information, so you wouldn't have to worry about filling that in. So I'm going to say no here and just click next. And then it's going to ask us about key people. Now, key people, that's what we call the individuals that are going to play a role within your documents in one form or another. So individuals that you're naming as executor, successor executor, guardian, successor guardian, your power of attorney, medical power of attorney, so on and so forth. They're going to be listed here. Even individuals that you're going to maybe leave a specific bequest to. You know, maybe you've got a coin collection that you want to go to your brother. Well, he would be listed here under key people. I do want to point out that your spouse and your children, they're listed under your family, right? We've already done that, so you're not going to list them again under key people. Spouse and children go under your family. Everyone else goes under key people, okay? So let's add some. I'm going to click add, and let's say we're going to name Rick Smith. We'll say that's his brother, and we'll say that he lives in Louisville as well. And here, I want to invite my brother Rick. We want to invite our brother Rick here because, you know, he's going to be playing a role in these documents. Maybe he's going to be named as the guardian of my child. And I want to make sure that he's taking care of his planning too. I want to make sure that he's being responsible and taking care of his planning so that when he eventually potentially gets custody of my child, that I don't have to worry about that. So what this is saying here is, do you want to send NetLaw information, just the information on how he can create these documents to your key people so that they can do this for themselves? It doesn't invite them to your account. It just invites them to NetLaw so that they can create their own account. So I'm going to do that because that's, I think, kind of important from a family standpoint. So you just enter in their email address, and it's already clicked yes here, and then click OK. And then what that does is it sends your key person, your brother, your sister, whoever that may be, an email that says, hey, you might want to check this out and create these documents to protect yourself. And let's add a couple of more. Let's say the sister, and we'll say that let's say that she lives in Nashville, Tennessee. So the person that you name does not have to be right there in your home state, doesn't even have to be in your country. I do want to point out, however, that naming somebody outside of your country It is possible to do that. There are some things to consider, such as, how difficult is it going to be for that person to manage your affairs from afar? If they don't live in your state or in the country, the court, depending on the court and depending on the judge, might require that they post a bond. So things like that. It's not impossible, but just some additional things to consider. So if you're thinking about that, and that's a concern for you, maybe you are maybe you're first generation to this country and you don't have any close family members here that you want to name as guardian or executor or trustee or what have you, you might want to consider, especially in the executor or trustee category, naming maybe a bank or trust company to serve in that capacity. Just something to think about. So let's name one more key person here, and we'll say that this is a sister-in-law, and we'll say that she lives in, Indianapolis, Indiana, and we'll send her some information too. And there we go. So let's stop there with 3. We'll name 3 key people and we'll move on. And here we are. So to create documents, let me just kind of walk you through the navigation bar here real quickly. So to create documents, you're always going to click on Smart Guide. The vault here, that's where your documents are stored. Attorneys can be found here under the Attorneys tab. Your account tab here just sets up where you can change your passwords, you can, update your billing information down the road, things of that nature. Refer a friend. So if there's other people that you care about that haven't, created these documents, maybe that's a close friend that just had a baby and they need to name a guardian for that new baby, you can refer them to NetLaw just by clicking here on Refer a Friend and entering in their first name, last name, phone number, and email address. But let's create some documents here. I want to show you here from the Smart Guide tab. If you look over to the right-hand side, it says Document for John Smith, which means that if we start creating documents, we're going to be creating documents for John. So when John is ready to create documents for his wife, he would just click on this drop down here and then click on her name, and then he could create documents for her. He does not have to go through the getting started process again. Everything that he entered in when he went through the getting started process, all of that information that is common between the two of them will be there for her as well. However, she may have other key people that she would want to name differently from his. So that might be the only difference, is that she would go in and maybe add a couple of key people to that list. But let's go on ahead and create a will and trust for John. So I'm going to click on that link over here to the left. Every section here comes with a little video that you can watch that tells you a bit more about the documents, what they do, and why they're important. I'm just going to skip right over that. And then we'll go right into creating documents here. So take a look at the screen here. I want to show you just a couple of things. You'll notice that it's starting out by asking you to name an executor of your last will and testament. Right? So what if you're not sure what an executor is, or you've got questions about executors? Over here to the right-hand side under Helpful Tips is questions and answers that relate exactly to what it is that we're asking you to do or talking to you about here in the middle. So oftentimes you can find answers to the questions that you have right here over to the right-hand side. Also, you'll notice this little QA tab. When you hover over that, the little pop-out comes up, and there's a place here where you can search for instant answers. If we have somebody online manning live chat in our office, it will say available here, and you can chat in real time with somebody in our office. We typically don't have live chat manned on Sunday. Or you can just send your contact information and ask us to reach back out to you during business hours, and we will do that. So lots of places where you can find help here. But let's go on ahead here and name an executor of the last will and testament. When you click on the drop down, you'll see that everyone that John named in the getting started process is now listed on this drop down. That's why it's important to go through that getting started process first. If you had skipped that process and tried to start creating documents, this drop down would be blank, and you cannot manually type in this field. So you'd have to go back and do that anyway. So save yourself some time and just go through that getting started process first. So let's name his wife Jane as the initial executor. So when John passes away, he's saying here that he wants his wife Jane to be the executor of his will. But what happens if Jane has predeceased him? Or what happens if she has dementia or otherwise cannot serve as his executor? Well, you can name an alternate executor. You can name one alternate, multiple alternates, or you don't have to name an alternate right now at all if you don't want to. Keep in mind that these documents can be updated and changed at any time. It's completely at your control. So let's name one person here as an alternate. Click on the drop down and let's just click on, well, that would be his sister-in-law. So let's click on his brother. Now he can name multiple alternates if he wants to, just by clicking on multiple names. Very easy to do. But let's just say one person in this instance and then click next to continue. Guardian of minor children. Now this is an example of why it's vitally important that you be very precise when you enter in birth dates. So the system was designed to be smart technology. So when you entered in your child's birthday, if you entered in a date that indicated that child was under the age of 18, the system's going to recognize that and it's going to prompt you to name a guardian for your minor child. If your child's over the age of 18, you're not going to see that question. So let's name, let's say, the sister, and then click next. And then it will ask for an alternate. So if the sister that you've named has predeceased you or for whatever reason can't serve, who do you want to be the guardian? So you can name one person, multiple people, or you don't have to name an alternate at all at this time if you don't want to. Click next. Then the trustee of your living trust. Now remember, I mentioned that when you create a trust with NetLaw, when you create a revocable living trust, you will be your very own first trustee. You will be the initial trustee of your own trust. So what this is asking for here is for you to name a successor trustee to step into your shoes upon your death or disability. So by clicking on the drop down, you can name one person, multiple people, or none right now if you don't want to. Let's just click one, and then we'll say we're going to click on the spouse. Then click next. Possible future trustees. So what this means and what this is asking you, it's telling you that it is possible that before this trust ends, the individuals that you have named as trustees and successor trustees may pass away before this trust ends. And if that happens, would you want to give the ability for an adult child or another adult descendant of yours to be allowed to become trustee of this trust? It is a personal decision, yes or no. If you say no, that you don't want an adult child or another adult descendant to be allowed to become trustee, then you're basically stipulating that a bank or trust company then be appointed as successor trustee. So that's what that means. Again, it's a personal choice. I'm just going to say yes and click next to continue. Specific bequest. This would be bequests that you would want to make to certain individuals of certain pieces of property or dollar amounts. So the example I gave earlier was your coin collection. Let's say you've got a coin collection that you want to leave to your brother. That would be an example of a specific bequest. You can leave, I think, up to 40 specific bequests if you want to. You don't have to make specific bequests if you do not want to. You can make specific bequests to individuals and charities. So if you've got a charity, which I know all of you do here on the call today, that you're very passionate about, you can make a specific bequest to that charity so that upon your death, they get a certain amount of money or they get a particular piece of asset that you own. Maybe it's shares of stock or whatever the case may be. You can do that from here. This is where you would do that. So I'm going to show you how to do a specific bequest for a charity and for an individual. I'll show you one of each. So I'm going to click yes and then click next. and I'm going to click Add. So here you can see you can either click to make a bequest to a charity or an individual. Let's start with the charity first and put in the name of the charity that you want to make a bequest to. One that I'm very passionate about is the American Red Cross. So I would leave a bequest to the American Red Cross. You'd put in their city and state. And let's say that we're going to do a dollar amount for this example. And I'm going to leave the Red Cross $10,000. And here is where I can say whether or not I want that bequest to be paid at my death, regardless of whether or not my spouse is living, or at my death only if my spouse has predeceased me. Again, it's a personal choice. I'm just going to click one and click OK. And here you can see there is my bequest of a charity to the American Red Cross of a dollar amount. I can edit that at any time. I can remove that at any time. Now let's do one to an individual. Clicking on the drop down, you can see everyone here that you named in the getting started process. What if you get to this point and you think, oh no, I meant to add my cousin because I want her to have my grandmother's ruby ring, and you forgot to do that? No worries. You just click over here on the right hand side where it says Key People, add that cousin in, and when you go back into this section, your cousin's name will be on the drop down. But let's just pick a sister here. And let's do an item this time. And let's just say again that it's the coin collection. You notice that I just said coin collection. It says over here in the instructions, describe the item, but don't include the word my, because that will just duplicate that word in your document. And then finally, do you want that bequest to be paid out at your death, regardless whether or not your spouse is living, or only at your death if your spouse predeceases you? I'll select the other option this time just for an example. And so here's our bequest to an individual of an item. I can edit that at any time. I can remove that at any time. And then let's click Next. So I've just made those two specific bequests of $10,000 and a coin collection. So what do I want to happen to all of my other assets? Right? Do I want to make a bequest of my personal residence? Maybe I want my home to go to the charity that the charity can then, sell for money to benefit the cause, or maybe I want that to go to my mom, or whatever the case may be. I really don't want to make a bequest of my personal residence. I don't want to parcel that out. I'm just for, demonstration purposes here. So I'm going to say no and click Next. So now what? How do I want the rest of my assets to pass? No, I don't have any other real estate. If you do, that's great. Maybe you've got a vacation property and you want that vacation property to go to one child and you want other property to go to another child. You can certainly do that. Remaining assets, kind of give you some standard options here. You can say all of the rest of my assets that I have not specifically bequeathed in other sections, I want that to either go all to my spouse if my spouse survives me, if not to my children in equal shares, or you can say all to my children in equal shares, or you can say all to named persons and or individual charities, and get very, very specific, dollar amounts and percentages and what have you. For this example, I'm just going to say all to my spouse if my spouse survives me, then if not to my children in equal shares. I'm going to click Next to continue. Take a sip of water. So your children's shares. This is where we're going to kind of get into how do you want to structure your child's inheritance. So first off here, it's asking, do you have any children that you want to omit from your estate plan? There are sometimes unfortunate situations where that is the case, right? Maybe you've had a falling out with a child, maybe they developed a drug problem, whatever the case may be. If that is the case, then you would just say yes, and then you would pick that child or children from the drop down. For this example, I'm just going to say no. And then next it's asking, do you want the inheritance going to your child to be held in a trust for the benefit of that child? If you say no, then it's just going to be distributed outright to your child at your death If they're over the age of 18, all at one time in a big lump sum. If they're under the age of 18, it'll be held in an account, a court-supervised account, until they turn 18, and then they'll get it all at 18. So by saying no, that's what happens. If you say yes, then we give you some options to choose from so that you can kind of structure the inheritance to that child and at what ages they can get outright distributions. I'll show you what that looks like. So here we go. These are the options that we give you to choose from. You can say hold all of the assets in a trust for the benefit of my child until my child turns 21 and then give everything outright to that child. Or you can say hold it until 25 and then give everything outright at 25. Or you can say hold everything for their benefit, give them half of it at 25 and the balance at 30. Or you can say, you know, let's structure it a little bit more. Let's hold it in trust for their benefit with, you know, outright distributions at 25, 30, and 35. Again, a complete personal choice. And those can be changed too. You can go in and change that at any time. Hopefully you can see how easy this is to go through this process. So ultimate disposition, that sometimes can be very confusing for people because you've just gone through and you've told us how you want your assets to pass, and now we're asking you for the ultimate disposition. So what does that mean, right? Basically what that means is if upon your death, everyone that you have named as a beneficiary within your documents, your spouse, your children, your sister, etc. If all of those individuals have passed away before you, then how do you want your assets to be distributed? So we've given you, again, some standard choices to choose from. You can say all of it to my heirs at law, or you can say divide everything 50-50 between my heirs at law and my spouse's heirs at law. Or you can say, no, I want to do named individuals and charities, and I want to get really, really specific, very much like you did in the specific bequest section. If you are unsure of what an heir at law is, what that means, look over here under helpful tips. We give you answers to those types of questions. It does vary somewhat from state to state, but typically it's going to be, your heirs at law would typically be parents of living, brothers, sisters, nieces, nephews, aunts, uncles, cousins, kind of those types of beneficiaries. I'm just going to check 50-50 for demonstration purposes and then click next to continue. What's going to happen now is the system's going to prompt us with this box that's going to let us know that we have successfully gone through and answered all of the questions in this particular section. So you know that you've done that. You haven't missed anything. So click Assemble Documents, and now the system is generating your documents. So again, this is not a fill-in-the-blank form system. So what the system is actually doing now is pulling together line by line, paragraph by paragraph, your documents based on the information and the answers that you just entered into this system. So it's custom drafting these documents for you. Once they are completed, they're going to show up here in your vault in just a moment, and I'll show you what that looks like. It takes just a couple of minutes for this to process. And we're nearing the end, guys, I promise you. Keep in mind that we've only been going through and creating these documents for about 15 minutes, and I've been doing a lot of commentary. So it really goes by pretty quickly. So here, it moves us over to the vault. So you can see that tab is highlighted there where it says My Vault. And right here are all the documents that we just created, that we just went through in the system, custom drafted for this particular client. So depending on the size of your screen and the resolution that you have, if you're like me and you can barely see, then you've got your screen resolution set really big and you might have to scroll down to see everything that is right here. We have calls sometimes from clients that say, well, I'm in my vault and I only see about 3 or 4 documents. Where's everything else? And we have to tell them, well, scroll down and then you'll be able to see everything. So, I mean, I fall into that category because I'm blind as a bat. But anyways, let's take a look here of what you've just created. Starting at the top is the signing instructions. We call them execution instructions. I hate that word, especially when you're talking about a will and dying. I hate using the word execution, but basically that just means how do you sign this document? What do you need to do in your state to properly sign this document so that it is recognized by the court as being self-proving? That's what this is going to tell you. And it does differ from state to state. So we get very specific, Make sure you're paying attention to these signing instructions. Right below that is the will that we've just created for this client. Below that are the signing instructions, the execution instructions for the trust. Below that are the funding, F-U-N-D-I-N-G, funding instructions. So if you want to fund, F-U-N-D, fund your trust during your lifetime with your assets so that upon your death, your family doesn't have to go through probate, you're going to want to take a look at these instructions, and you're going to want to follow those instructions to transfer your assets into the name of your trust. Creating the trust is a great first step. Signing the trust is a great second step. But guess what? If you don't move assets into that trust, you're not going to avoid probate. The assets have to actually be owned by your trust when you pass away for them to avoid the probate process, which means that you have to take steps. You have to take this trust to your bank, retitle your bank accounts into the name of your trust. You have to go to the DMV, retitle the name of your car into the name of the trust. If you've got a house, you're going to want to create a new deed that lists the trust as the owner of that house. You know, writing out a list of assets and attaching that list to your trust doesn't fund the trust. You have to actually take steps. Okay. Right below that is your trust itself. There is the trust document right there. And then below that is a certificate of trust. A lot of banks in particular, when you're transferring title to a bank account, they want a certificate of trust to have on file, and we've provided that for you here free of charge. So what I want to do now is I want to open up this will, and I want to open the trust so you can see what it is that we've just created. To do that, you're going to click on download. So I'm going to download the will first. And then next to the Revocable Living Trust, I'm going to click on download to download the Revocable Living Trust. Now again, guys, creating these documents is a great first step, but you're not done. You have to download the documents. You have to print the documents. You then have to properly sign the documents and get them witnessed and notarized according to the instructions. Then and only then are these documents binding and effective. Then and only then. Okay? And if you want to take that next step, which I encourage you to do, by scanning those signed copies into your vault, so you've got a copy safe at all times, I really encourage you to do that as well. So let's open up the will here. So I am going to, let me close this window. And let me make this screen a little bit bigger so you can see what we've just created. So here is the will that we've just created for John Smith. Article 1 addresses payment of debts. Article 2 here, there is our specific bequest of the coin collection. So this is going to handle, in your will, it's going to handle like the bequest of tangible personal property, like a coin collection or gun collection or jewelry, anything like that. It's tangible personal property, and that's going to show up in the will. So what about the rest of the tangible personal property? That is identified in Article 3. So in Article 3, that's going to say here, depending on how you've answered those questions, when we went through this for John, we said that he wants everything to go to Jane, his wife, if she survives him. If not, then to his children. So all of those pieces of tangible property, clothing, jewelry, furniture, collections, what have you, would pass to Jane if she's living. If not, then equally to the children. Everything else is considered residue, residuary estate. So everything else that you own, real estate, bank accounts, investment accounts, all of that is going to be addressed under Article 4 here. And if you've ever heard of the term pour over will, P-O-U-R, pour over will, that's what this is. And this is that pour over provision. So for example, you do your will and your trust today. You take some of your assets that you own today and you move them into your trust, and life goes on. Maybe you forget to move some assets into your trust. Maybe you acquire assets after the fact and you forget to title them in the name of your trust. Well, with this pour over provision, it will get those assets over into your trust eventually after your death. So those assets, unfortunately, will have to go through the probate process before they're distributed over into your trust, but they will get there eventually so that they can then be managed and distributed according to the terms of that trust for your beneficiaries. So it's really important that you have both of these pieces here, the will and the trust, because they work together. Continuing on here, the appointment of executor. Here are the executor powers. Again, you can see this is very specific to your state. This is not, again, a fill-in-the-blank form. Payment of taxes, identifying your child. This is something else, too, that a lot of people ask. So I've got one child today, and I set these documents up. What if I have more children later? Do I have to go in and update these documents? No, you don't have to. You certainly can if you want to, but if you don't, it's already addressed in here under this miscellaneous provision. So here it says the term my children shall refer only to Brooke Smith and any child or children hereinafter born to or legally adopted by me. So any children that you have after the fact, any children you adopt after the fact will be considered a child of yours under this document. So you can certainly go in and update that if you want to, but you don't have to. I'm not going to go through everything here, but I wanted you just to see how robust and detailed this document is. Now let's open up the trust. I want to show you what that looks like. So here is the trust that we just created. Again, you'll see that John is his own trustee. So he is his own trustee during his lifetime until his death or disability. This is where we identify the name of the trust, the beneficiaries of the trust. Again, we also say that children will include any children or child hereinafter born to or legally adopted by me. So they're covered under the trust as well. Here's a lot of kind of statutory code language. If you're really bored, you can read all of that and look up the statutes. It's super fun. Let's see here. At your death, you want everything to benefit your spouse according to what we entered into this document. So here, upon your death, if your wife has not predeceased you, she receives everything. If she has, then it's going to then be distributed according to the trust document here that is going to hold those assets for your children. So if you have more than one child, it'll hold those assets in equal shares for each child. Let's say that you have two children, but one child passed away before you, and that predeceased child had children of their own, your grandchildren. Well, then that share for that predeceased child would be held for the benefit of that child's children. That's how that works. And that would be all according to Article 6 here, which is the Descendants Trust. And you can see here are those ages that we set out. 25 under Article 6.2, 30 under Article 6.3, 35 under Article 6.4. Now that doesn't mean that your child can't benefit from the trust until they reach those ages. That just means that they can't get any large outright distributions until they reach those ages. The entire time the assets are being held in trust, the trustee has the duty and the responsibility to make distributions to or for the benefit of your child for their health, education, support, and maintenance. It's unlimited for their health, education, support, and maintenance. So that's a pretty broad standard that will pay for medical needs, health insurance, tuition, room, board, books. It can put a roof on their house, tires on their car, things of that nature. So they're completely taken care of. And then once they get to certain ages, then they can get some outright distribution. So that's what that does. Again, I'm just going to kind of scroll through here, let you see some different provisions, the successor trustee provisions. So again, guys, this is law firm quality. This is the exact same trust and will and everything else that you would get if you were to come and see us in the private practice here at Hargrove Trauber. So going back into the account, I'm going to show you just a couple of other things, and then I'll open it up for questions. Back here in the vault, I want to show you how easy it is to use this vault to store other information. We have some standard folders set up here for you already to kind of try to help you organize your information. You can do that. So let's say that you want to scan and upload copies of your insurance policies into your vault so that you've got them there if something ever happens. So to do that, you would just click here where it says insurance policies, click on that folder, then scroll down so you can see it over here to the right, then click on upload file. Once you do that, you're going to find where you have saved that scanned policy on your computer. So here is a policy that I scanned. You highlight that, click open, and in a moment it's going to pop right into that folder. And there it is. It does not get any easier than this, right? Let's say that, you can do the same with deeds, the same with bank account and investment account statements. Maybe you've got, you want to put your tax returns in there. Or maybe there's not a folder already there and you want to create a folder. Maybe you want to save your vacation photos in here. To do that, you would click on Add a Folder, and then just type in, what you want to title that folder. So let's say 2017 vacation photos. Click Add. In a moment, that folder will be added over here to the left-hand side, and there it is. Click on that folder, scroll down to see it, click on Upload File, find where you saved the photo or photos that you want to store in that file, highlight it, click Open, and it'll pop right in there, just like the life insurance policy did. So easy, guys, so easy to do. Here is where you access the attorney network. Clicking on the attorney tab, it's going to default to your state of residency. You can look at lawyers in other states just by clicking on the drop down if you want to. But from here, with each of these attorneys, you can click on View Profile to see more information about that attorney. Where did they go to law school? How long have they been practicing? What are their rates? What are their hourly fees? Do they give a free consultation? We even give you a map to their office, their phone number, email address. This is where you click to see the full profile of that attorney. So it's really just giving you more information, giving you more options so that you can choose who you want to engage for more services if you need them. If you don't, that's fine too. So what I'm going to do now, guys, is I'm going to go back to the PowerPoint, and I want to open up this last slide here, and so that you can have our contact information. There's our support email and our support phone number. So if you have, questions as you go through this process, or if you think of something later, you can reach out to us. And also, guys, Through is an amazing, amazing resource for you all. He is so good, so knowledgeable, so patient. And I want you to really take advantage of that incredible resource. He is just a wealth of knowledge. That doesn't mean that you can't reach out to us at NetLaw. You certainly can. We love hearing from you. But I really want to let you know just what an incredible, valuable resource you have in Through. He is just an amazing person. He's an amazing professional. He's become a good friend of mine, and I encourage you really to rely on him for as much help as he can possibly give you. So what I'm going to do now is let me scroll through here and see if anybody has questions. I don't see any hands raised. I'll scroll through here, make sure nobody's got their hand raised. And if not, then I'll open up the questions box and see if anybody, I've got one person here that's got their hand raised. Praveen, I'm going to unmute you, and you should be able to speak now. What question do you have?
Sure. Just, I joined a little bit late. I just wondering, how much you guys charge for this, helping us in writing the estate planning,
Right. So the premium estate plan that I highlighted at the beginning of the presentation, if you weren't on yet for that piece of it, the premium estate plan is $600. That includes documents for both spouses, so 2 sets of documents. It includes your last will and testament, revocable living trust, financial power of attorney, medical power of attorney, advanced directive, HIPAA authorization, the life vault, which is unlimited data storage, access to the attorney network, and again, including documents for your spouse for $600. That can be paid all at one time, or you can finance that over the course of 12 months for $60 a month. We also have a package that does not include the trust. It's the will, financial power of attorney, medical power of attorney, advanced directive, HIPAA authorization, the life vault, documents for your spouse. It just doesn't include the trust. That package is $400. Again, you can pay for all of that at one time, or you can finance that over the course of 6 months for $40 a month. We also have a standalone life insurance trust. That's a little bit more of a complicated document, but you can still create it on your own. The irrevocable, and it is an irrevocable, not a revocable, an irrevocable life insurance trust that's priced at $700, and that particular trust has to be paid in full. We don't offer a financed option for that trust. Any other?
And do you mind sharing the slides? As I said, like, I apologize for the late in joining this webinar.
Absolutely.
Do you mind sharing those?
No, not at all.
Yeah.
I've also recorded this. So what I will do is I will send the recording and the slides to Tharu, and he can then distribute it to everyone today. Okay?
Great. Thank you.
Wonderful. Any other question before I mute you again? Okay. All right. Let's see if there's any other hands raised here. Prasad, I'm going to unmute you. Hi there. Prasad?
Yeah, Dad? Nana? Yeah. Can you hear me?
I can. Hi there.
Yeah. Hi, I'm his daughter, and he went upstairs real quick.
Sure, sure.
Yeah. Give me about 2 minutes, and I'll bring him down. Okay.
Okay, no problem. I'm going to mute you and then see if other hands are raised, and I'll come back. Okay. Let's see. Krish?
Yes. Hey.
Hi.
Are you able to hear me? Yep. I posted a couple of questions in the question box.
Okay. Let me see.
One of it I have is, can we name spouse as the executor or trustee of the irrevocable trust?
Yes. Yes. And that's very common for married couples to name each other. Yes.
I see. Thank you. And the other question I have is, can we name any foreign or India-based assets and add them in the will or the irrevocable trust or the revocable trust?
You can. Your trust can own foreign assets. You would just have to go through that foreign country and any institution that, if it's a bank or investment or if it's real estate, go through, the processes that are required in that country to transfer ownership. But you can have ownership of foreign assets within your U.S. revocable trust. Yes.
I see. So I understand for a irrevocable trust, there is some action that needs to be happened to re-register the ownership to the trust itself. But what about the will? In the will, there is no need of any transfership or anything like that. Right?
No. None whatsoever. And if you take your assets and move them into your trust so that upon your death you don't own anything in your individual name, then you don't have to do anything with the will at all. It doesn't have to be filed or recorded anywhere because you can avoid that whole process by having those assets owned by your trust.
I see. And can we do the other way around too? Means can we just have the will and not go through the process of having a revocable trust? You
can certainly do that, but you would be subject to probate. You would have to go through the probate process.
I see. Okay.
All right. Great. Thank you. Let me go back to Prasad. Bear with me a moment. Let me find him again in the list. Okay. Prasad, can you hear me?
No, he's still not here.
Okay. All right. I'll come back. No problem. Let's see. Let me go to another hand here. Oh my, I'm going to so mess up this name here. Pashupathi.
Yeah, that's me. Okay, so can you just elaborate a little bit on the probate process? You said if there is just a will and if there is no trust enabled, it has to go through probate process. So how is that? I'm sorry if you already covered, but I joined a little late as well.
Okay, real quickly, without going into as much detail, what happens if you pass away with assets titled in your individual name, regardless of whether or not you have a will, those assets are subject to the probate process, which means that they are going to have to, basically, it's a court supervised process, it's a public process, notice of your death is filed in the newspaper, those assets are frozen for a period of time by the court to give those creditors a period of time to come forward and file a claim against your estate, which means your family can't access those assets during that period of time to pay bills and support the family. Also, there's attorney's fees and court costs associated with that. On average, in most states, it's about 6 months is the minimum amount of time that your estate has to be kept open and that those assets are inaccessible by your family. By having those assets instead owned by your revocable trust upon your death, you avoid that entire probate process.
Okay. And then even if you have a trust, you said everything has to be transferred to the trust name to have those accessible, is it?
Yes, it has to be owned by the trust upon your death to avoid that probate process and to make sure that those assets are immediately accessible by your family.
Okay. So I just have one more question. Is there any cost involved in transferring the assets owned by both spouses onto transfer to trust?
Typically, the only cost involved in that is with real estate. In most instances, you're going to need assistance in creating a new deed to move that property into the name of your trust. We do have vendors, deed vendors that we work with that will do that on a flat fee basis for you. You're going to be looking at $150 to $200 to do that. And
Okay.
I'll show you how to access that.
So it's not like paying the whole taxes again to transfer.
No, it's just a deed. Okay, let's move to another question here. Let me go to, let's see. I'm going to read some questions here. Are the trust and wills public documents? It appears not. Your will is public if you go through probate. So if you have assets in your individual name and your family has to go to probate before those assets can be transferred, the probate is a public process, which means anybody can go to the courthouse. So let's see, Fen Kumar asked that question. So if you were to pass away, I could go to the courthouse and pull a copy of your estate file. Anybody can do that and see everything that you owned, what it's valued at, who your beneficiaries are, even who your creditors are. Some counties even have those records available online. So another question here, could my parents or siblings in India be guardians? They can. That is that's something that you really need to think through. And it also may be something that you might want to talk to an attorney about, because what if your parents or your siblings are not U.S. citizens? Do you want your child to go back to India? Maybe they've lived most of their life here in the U.S. Do they want to go back to India if something happened to you? If not, what is the process and how long is it going to take to get your family member a visa or a green card or what have you here in the U.S.? So those are just some things to think about. And unfortunately, again, I can't give you legal advice on that particular aspect or any aspect for that reason. NetLaw is not a law firm. Another question here, is there a yearly charge to maintain the documents? Great question, and thank you for asking that, Suri. The fee that you pay for the set of documents, so the $400 or the $600, that covers you fully for the first year. That covers all of your documents for the first year. Any changes that you need to make, updates that you need to make, unlimited document storage in that vault, unlimited access to the network of attorneys. After the first 12 months, if you want to maintain the ability to make changes to your documents at any time, if you want to maintain the ability to keep adding new information to the vault, it's an $8 a month fee. So less than $100 a year, $8 a month to maintain that ability. If you choose not to maintain your account, that's okay. What happens at that point is all of your documents are still effective. They're all still yours. You keep your vault and everything that's currently in the vault at the time that your account goes inactive. You just lose the ability to make changes to those documents, and you lose the ability to add new information to the vault. You always have what's already in there, and your documents will remain binding and effective. That does not invalidate your documents. Let's see here. Question here about transfer taxes of real estate. If you're, again, guys, keep in mind that your revocable trust maintains your social security number. So you're not really transferring it to a separate taxable entity. So that does not trigger any kind of tax on that transfer. Let's see, another question. Bank accounts, mortgages owned by me and my spouse together. Do I need a trust just in case something happens to one of us? So what you're saying here is that everything is owned jointly with rights of survivorship. I'm assuming that's what you're saying. So at the first death, everything will pass automatically to the survivor and will pass outside of probate, because joint assets, anything that's owned jointly with rights of survivorship, will pass automatically to the survivor. However, at that time, the survivor then owns all of those assets individually. So the example that I gave earlier is, so using myself, my husband is 53, I'm 44. So we set up our documents today, right? And let's just say that we own everything jointly with rights of survivorship, so we're not worried about probate because we're going to avoid probate, right? Well, we're going to avoid probate at the first death. But let's say that I then live another 30 years after my husband dies. So then I'm, 74 or maybe even 84. Am I going to have the ability, the mental ability, capacity, desire, what have you, to then go through the process of figuring out how, at that advanced age, how to transfer and move everything at that time? Am I going to want to do that? Probably not. So in my opinion, do it while you're young. Do it while you're young and capable and able-bodied. Don't wait until, you're 70 or 80 and having to figure that out on your own 30 years from now. Now, that being said, doesn't mean that you have to do it right away, but just consider those things, because, what typically happens as you get older? Are you in better health as you get older? Do you have better mental capacity as you get older, or does it get worse? And just keep that in mind. Another question here, in what situation would we use the will or the trust, and what is best? Again, you're asking me for legal advice that I can't give you. The example I gave earlier is, part of this package, the premium package includes the will and the trust. So if you're buying the premium package, you're going to want to create both because they both work together. If you're just using the basic package that doesn't include the trust, that's okay. The real key here is, how important is it to you to avoid probate, to avoid that creditor's claim period, to avoid paying the court cost and attorney's fees associated with probate? How important is that to you? And that's a personal decision. If you've got children, do you want to structure their inheritance so they don't get everything in one lump sum when you pass away? Those are some things to consider. Let's see. Let me look at other questions here. Great questions, guys. Let's see. Yes, I have recorded this session, and I will send the recording and my slides to Tharu that he can then share with all of you. Question here, do I need to register the living trust with any State Department or court authority? No. Revocable living trusts are not subject to court jurisdiction. You do not register them or file them anywhere. Sereni's asking, how does probate work for joint partners on a title? Again, it depends on, is that joint with rights of survivorship? If it's joint with right of survivorship, it passes automatically to the survivor and probate is not necessary. However, there is another form of joint ownership. It's called joint tenants in common. Joint tenants in common. So think about business owners. let's say that you own a business together. One person owns 50% of the business, the other person owns the other 50% of the business. It's a 50% undivided interest, which means that 50% is going to be a probate asset. So that would go through probate. Basic difference between a will and trust. Depending on how you use the documents, there's not a whole lot of difference. It's going to be used to dictate and determine who receives your property and when. Biggest difference is the trust can help you avoid probate. The will not avoid probate, and it's going to be determined on how your assets are titled at the time of your death. If you've got your assets titled in your trust at the time that you die, those assets escape probate. If those assets are titled in your individual name when you die, they're going to be subject to probate regardless of whether or not you have a will or a trust. Someone is asking here about security. We do have a security white paper available on our site that you can read in very much detail, all the little technical terms. I'm not a techie, I'm a legal person, so I would just totally botch it if I tried to describe what we use, but we basically use the same protocols that all of the major institutions use, banks, trust companies, financial institutions. We take all of the most advanced protocols possible. We have independent third-party audits of our system every quarter. But everyone knows, guys, that nobody's bulletproof, right? All we can do is to take the most stringent measures necessary, and we certainly do that. Let's see here. Okay, looks like I've gone through all of those questions, and I think that I've gone through all of the raised hands. Let's see. Bear with me a moment while I'm scrolling through here. I want to make sure I'm not missing anybody. Okay, I've got one raised hand here. I'm totally going to mess this up. Sujit, S-U-J-I-T. I'm going to unmute you. I'm going to try to unmute you. Hi there.
Hi.
Hi.
Yeah, hello. Yeah, thank you for the informative session, and I have a couple of questions regarding will and trust. You mentioned one point that the will and trust, they are specific to the state. So tomorrow, right now I'm living in Minnesota, tomorrow I go to some other state. Do I need to make changes into will and trust or revise it, or it still stands valid even if I'm anywhere in the US?
Yeah, good question. Great question. So the way that works with wills and trust in particular, when you create, let's say, I think you said you were in Michigan right now. Is that correct?
No, I'm in Minnesota.
Minnesota, sorry. Knew it started with an M, a northern state. So you're in Minnesota and you set up your will and trust and you follow the signing instructions that we provide with the will and trust so that you properly sign it according to the requirements of Minnesota. And then you move to Alabama, where I'm originally from. Since you executed those documents in Minnesota according to the laws of Minnesota, the state of Alabama will recognize that as a valid and legal document. The difference is that if Alabama requires 3 witnesses and a notary and Minnesota only required 2 witnesses and a notary, the Alabama court might make you produce your 2 witnesses to come forward and authenticate the signature of the document. So in some instances like that, you might want to go ahead and take the extra step of just updating those to be specific to your new state's law. In particular with regard to your healthcare documents, because healthcare documents are vastly different from state to state. So if you move to a new state, you're definitely going to want to create new healthcare documents for that new state. Does that make sense?
Yes, it does. Yep.
Okay.
And another question is, let's assume if something goes wrong when person is out of the US in some other country, okay, then how will it work in that case? That's one question. And second one is, the trust needs executor or trustee. I don't know the legal word, trustee. And is it possible that that trustee can be from some other country?
It is.
In my case. Okay.
Yes, it is. It is possible. Again, kind of the challenges there is, is that person in a foreign country, how difficult is it going to be for them to administer the trust from afar? That's typically not as difficult as having a foreign person be named as the executor under your will. A lot of times that poses more problems. It's not impossible, but there's a lot more that has to be done in the probate process that involves the time of that executor that could make it not impossible, but a bit more challenging if they're out of the country. So for that reason, I just mentioned that you might want to consider maybe naming a bank or a trust company as your successor executor under your will, just because of the logistics of it.
Okay, but can we do it like, let's assume I'm making trustee from someone from this country who is not my relative, but who is my friend or someone. But can we make him trustee for a limited number of times, like few months, and then can I mention that this person should be trustee for 3 months, and then it has to be someone from my relation who is back home or who is from India?
If you want that kind of customization, because that's a pretty detailed customization, you would want to connect with one of our attorneys to add in that level of detail to your document. You can't get that specific with our drafting system.
Got it. And just last question, let's assume if something goes wrong, how long it takes to execute the clauses written in a trust? Like few months or year, or how long it takes?
When you say execute, what do you mean by that? To sign the document?
For example, no, let's assume if something goes wrong, if person dies or the husband and wife, they die. In that case, when it comes to the guardianship or transferring the assets to trustee, how long that entire process take?
Gotcha. It depends on where you live. So you said you are in Michigan, Minnesota, sorry. So let me, I'm going to pull up that information for you really quick. I'll tell you how long the creditor's claim period is in Minnesota. So let me click on resources and type in creditor and click search. So the creditor's claim period is the minimum amount of time that your estate would have to be kept open in probate. And in Minnesota, that is 3 months.
Okay, and when it comes to the guardianship?
That's automatic. So what happened? Well, it's automatic in the sense that once you initiate the probate process. So again, when you die today, your family's not going to run to the courthouse tomorrow, right? There's going to be a little period of time. There's going to be some grieving, there's going to be a funeral, there may be a wake, what have you. So the probate process begins on the date that they go to court and file a copy of your will, right? That also is the day that the creditor's claim period begins.
Okay.
So if your family, grieves for a while and it's 2 or 3 months before they take the documents to court to start the process, it could extend that period of time before assets can be transferred, before an official guardian is appointed by the court. Okay?
Okay.
Does that make sense?
Yes, thank you. Thanks a lot.
You're welcome. Okay, let me scroll through here and see if there's any other hands raised that I haven't gotten to. Swetha. It's Swetha. Let me see here if I can unmute you. Bear with me a moment. Looks like you've got yourself muted, and I can't unmute you on my end. Okay, let me scroll down, see if I've got other hands up here. Doesn't look like I do. And we are running really close on time here. Let me open up the questions box again to see if anybody else has entered in any other questions. Let's see, I do have a few more that have come in here. Bear with me a moment. Minal says, is there a rule of thumb of how much a net worth is required to set up a trust? No, there's not. There's no rule of thumb. There's no particular age. There's, this is something that really, is, it's going to depend on your personal situation and what your goals are. What you set up and how you set them up. Do you have children? Do you want to structure their inheritance to make sure they don't squander it away at a very young age? Do you have assets in your individual name that you want to avoid probate so that your family can immediately access those assets without having to pay a lot of fees and going through that probate process? So there's really not a particular net worth or age that someone needs to be before they start thinking about this. Is one will enough for the whole family? No. Wills are individual. So spouse and spouse. I used to always say husband and wife, but now that most of the country recognizes same-sex marriages, I say spouse and spouse. Each spouse has to have their own will. There's no joint will. However, in community property states, you can have a joint trust. There's about 9 community property states in the U.S., and I will even pull those up for you to show you what those are. So in the resources box, I'm going to type in here community. Click search. Here is the list of the community property states in the United States. Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Alaska is an opt-in state. You can opt in if you want your trust to be created and treated as a joint trust. Another question here, will our data and documents be shared with any third-party marketing companies by NetLaw? Absolutely not. No. We're bound by confidentiality. All of that stuff is kept very confidential. As a matter of fact, if something happens to you, nobody can even get access to your account without going through certain protocols with us. Again, providing a copy of your death certificate, providing a copy of their identification. Then we check to make sure that they're named in your document. So all of that's kept private. And I just answered Kieran's question. That's how they get access. He asked, how do they get access? They have to come forward and provide proof of identification, proof of death, that kind of thing. But I do want to point out, however, guys, if you trust someone enough to name them in your documents, maybe name them as a guardian of your children, executor, name them as someone that will make healthcare decisions for you. If you trust them enough to name them in your documents, you probably trust them enough to give them a copy of those documents as well. So I would, I would think about that if I were you. Another question here, if we've identified somebody who is outside of the U.S. as part of the ultimate disposition, how then does that distribution of that asset make it to that person? The trustee of your trust or the executor of your will would contact that beneficiary, and that would be part of their duties and responsibility would be to make sure those assets are distributed to that beneficiary. That's how that works. Yes, again, this is being recorded. I will send the recording to Tharu along with my slide presentation that he can then share with you all. All right, guys. With that, I'm going to turn things back over to Tharu so he can make some parting comments. And I thank you again so much for your time and your great questions and your attention today. You all have been fantastic. Tharu, go on ahead.
Yeah, sure, ma'am. Thank you, everyone, for being part of this good, informative seminar. And thank you so much, Mr. Charles, for your patience and very detailed, explanation about all the sections. And every question you addressed is very great. And so thank you again. And so to whoever participated in this, especially ATA is leading this webinar, ATA team, so Shankar Bandi, Anil Reddy, Parmesh, Karnakar Garu, all the team. And thanks for choosing me as your service representative for the NetLaw and financial services. I will be happy to announce one good news that, anyone who want to purchase the NetLaw services using the link we provided in the email and messages, click on that, and everyone who purchased the service before November 19th, they always get the complete another set of the documents free access. Okay, so it's like a BOGO offer, buy one get one free offer till November 19th for all ATA members and whoever participated today in the webinar. And so that is, please utilize that opportunity, and they are saving, you can give it to that one. That's another thing. So any questions you have regarding this whole process, and I'll be happy to take your call and email a message, and I'll respond on timely manner. And if I'm not able to answer or I don't know, and Ms. Charles is always attentive and available and very, very helpful, and I'll get the information from her and pass it to you guys. So please don't hesitate to reach me. Once again, thank you for everyone who participated, and thanks again for Ms. Chelsea and ATA team.
Thank you, Tharu. Thank you for having me today. You guys have a wonderful rest of your weekend. Bye-bye.
Yeah, bye-bye.